Exactly 47 minutes ago, I received confirmation that changed everything in this case. Melania Trump's legal team formally declined the immunity deal my office extended 3 weeks ago. That agreement could have saved Ivanka Trump from decades behind bars. Instead, Melania chose silence over her stepdaughter's freedom. Within minutes of that rejection, new evidence landed on my desk that revealed the defendant's explosive reaction. What I'm about to show you isn't speculation or tabloid gossip. This is documented proof from federal witnesses, recorded communications, and sworn testimony. The defendant's response tells us more about his consciousness of guilt than any confession ever could. Before you dismiss this as family drama, understand the legal stakes we're dealing with here. Ivanka Trump is staring down 87 to 144 months in federal prison on multiple felony counts. Melania Trump possessed first-hand knowledge that could have reduced that sentence by half. She watched financial crimes unfold in real time across 4 years of Trump Organization operations. Her testimony would have corroborated documentary evidence my office has been building since March 2024. Instead, at 8:17 this morning Eastern Standard Time, her attorneys sent a 2-paragraph letter rejecting our cooperation agreement. No counteroffer was made, no negotiation was requested, just a flat refusal to testify against family members in exchange for complete immunity from prosecution. That decision triggered a chain of events I'm going to walk you through step by step. The evidence of the defendant's reaction came from 3 independent sources within 90 minutes of Melania's refusal. First, a Secret Service agent filed a voluntary witness statement describing what he observed at Mar-a-Lago. Second, intercepted communications between the defendant and his son, Eric, revealed direct attempts to pressure Melania. Third, digital forensics recovered a deleted social media post that remained live for exactly 22 minutes before being scrubbed. I've prosecuted organized crime families for 28 years. I've seen fathers turn on sons, brothers betray brothers, and wives refuse to testify against husbands. What makes this case different is the documentary trail that exists independent of any family testimony. But Melania's cooperation would have transformed a strong case into an airtight conviction. Let me show you exactly what she witnessed and why her refusal carries such devastating consequences for Ivanka. This isn't about one transaction or one meeting. This spans 4 years of systematic financial fraud. The timeline that led us here. My investigation into Melania Trump began on April 3rd, 2024, when her name appeared on subpoenaed bank records. She wasn't a target initially. She was a potential witness with access to information other investigators couldn't obtain. Her signature appeared on 23 separate financial documents connected to Trump Organization loan applications between 2019 and 2023. By June 2024, my team had conducted preliminary interviews with Melania under subpoena. Those proffer sessions lasted 7 hours across 2 days. She was represented by independent counsel, not Trump Organization attorneys, which told me she understood the personal legal exposure she faced. What emerged from those interviews was stunning. Melania had been present at 4 critical meetings where the defendant allegedly instructed Ivanka to falsify property valuations on loan documents. She had access to offshore account statements showing concealed income streams. She possessed text message exchanges discussing strategies to avoid IRS scrutiny. On September 12, 2024, I authorized charges against Ivanka Trump. 4 counts of bank fraud, 3 counts of wire fraud, 2 counts of tax evasion, and 1 count of conspiracy to defraud the United States. The indictment was 47 pages long and detailed a scheme involving $89 million in fraudulent loan applications. Here's what made Melania's testimony so valuable. She could place the defendant in the room when instructions were given. She could authenticate communications between father and daughter. She could explain the purpose of shell companies and offshore structures that appear throughout the documentary evidence. On December 18, 2024, my office extended a formal cooperation agreement to Melania's attorneys. The terms were straightforward. Testify truthfully about what you witnessed, and you receive complete immunity from prosecution for any Trump Organization-related conduct. Additionally, your cooperation would be presented to the judge as a mitigating factor in Ivanka's sentencing. Federal sentencing guidelines allow judges to grant substantial downward departures when family members provide cooperation. Typically, that means a 30 to 50% reduction in prison time. For Ivanka, that could mean the difference between 12 years and 6 years behind bars. Melania's attorneys requested 3 extensions. January 15th, deadline passed. February 1st, deadline passed. February 20th, deadline passed with no response. This morning at 8:17 a.m., the answer finally came. A terse letter stating Mrs. Trump declines the government's offer and will not provide testimony in any proceedings related to United States versus Ivanka Trump. No explanation was given beyond a vague reference to family considerations. Now, let me show you what happened in the 90 minutes after that rejection landed in my office. Because the defendant's reaction provides a window into his state of mind that no amount of legal maneuvering can obscure. The evidence of explosive reaction. At 9:03 a.m. this morning, Special Agent Marcus Reynolds of the United States Secret Service contacted my office. Agent Reynolds has been assigned to the defendant's protective details since January 2025. He's a 19-year veteran of federal law enforcement with an impeccable record. Agent Reynolds submitted a voluntary witness statement describing events he observed at Mar-a-Lago between 8:30 and 9:00 a.m. today. According to his statement, the defendant received a phone call from his lead attorney, Todd Blanche, at approximately 8:34 a.m. The defendant was in a private study adjacent to the main residence. Agent Reynolds was positioned 15 feet away, providing standard protective coverage. He heard the defendant's side of the conversation clearly. The agent's statement quotes the defendant as saying, "She's destroying this family to save herself." Melania knows exactly what testimony would do to Ivanka. The call lasted approximately 6 minutes. Agent Reynolds noted that the defendant's voice escalated in volume and profanity throughout the conversation. When the call ended, the defendant allegedly threw his phone across the room, shattering a framed photograph on the opposite wall. Agent Reynolds then observed the defendant place 3 additional calls over the next 20 minutes. Each call lasted between 2 and 4 minutes. During the third call, Agent Reynolds heard the defendant state, "Make her understand what loyalty means in this family. Ivanka is going to prison because your mother won't do what's necessary." That witness statement is now part of my case file. Secret Service agents are federal law enforcement officers whose credibility carries substantial weight with juries. This isn't secondhand gossip. It's a sworn statement from a trained observer describing what he directly witnessed. Evidence item 2 came from intercepted communications. Under existing surveillance warrants related to ongoing obstruction investigations, my office monitors certain communications involving the defendant and immediate family members. At 9:12 a.m. this morning, the defendant sent a text message to Eric Trump. The message read, "Your mother just signed Ivanka's prison sentence. She refused the deal. You need to talk sense into her before this gets worse." Eric responded at 9:18 a.m. "What do you want me to say?" The defendant replied, "Tell her there are consequences for betraying family. Tell her she's choosing the government over her own stepdaughter." That exchange continued for another 15 minutes. The defendant sent 4 additional messages pressing Eric to intervene with Melania. In my experience prosecuting obstruction cases, this pattern is unmistakable. A defendant attempting to pressure witnesses through family intermediaries. Evidence item 3 surfaced at 10:41 a.m. when my digital forensics team alerted me to a deleted Truth Social post. The defendant published a post at 9:47 a.m. that was deleted at 10:09 a.m., remaining visible for exactly 22 minutes. The post stated, "When wives choose prosecutors over family, they learn what real loyalty costs. Some people value their freedom more than their children's future. Disgraceful." Digital forensics captured screenshots before deletion. The post received 847 shares and 12,000 likes before being removed. Why does this matter legally? Because in federal court, consciousness of guilt is admissible evidence. When a defendant reacts with rage, threats, and attempts to influence witnesses, that behavior suggests awareness of criminal conduct. If Melania's testimony was irrelevant or false, why the explosive reaction? I prosecuted John Gotti Jr. in 1998 for racketeering. When his sister agreed to cooperate, Gotti responded with similar fury, public statements, family pressure, thinly veiled threats. The jury heard that evidence as consciousness of guilt, and it contributed to conviction. The defendant's reaction this morning follows an identical pattern. Immediate rage directed at the non-cooperating witness, attempts to use family members as intermediaries, public statements suggesting consequences for disloyalty. That's not how innocent people respond to witness decisions. That's how guilty people respond when corroborating testimony threatens their freedom. What Melania actually witnessed. Let me show you precisely what testimony Melania could have provided, because the specific details matter enormously. This isn't vague hearsay, it's first-hand observation of criminal conduct. Transaction 1 occurred on May 22, 2020, at Trump Tower in New York. A meeting took place involving the defendant, Ivanka, Melania, and 2 Trump Organization accountants named Michael Hyder and Susan Chen. The purpose was discussing a $63 million loan application to Capital One Bank. I have emails confirming the meeting was scheduled. I have calendar entries showing all 5 attendees. I have testimony from Michael Hyder, who accepted a cooperation agreement in November 2024. What I don't have is Melania's first-hand account. Hyder testified that during this meeting, the defendant instructed Ivanka to use 2018 property appraisals instead of current 2020 valuations on the loan application. The 2018 values were 40% higher than 2020 market assessments. That's textbook bank fraud, knowingly providing false information to obtain a loan. Melania was seated at the conference table throughout this discussion. Her testimony would have corroborated Hyder's account and eliminated any defense claim that Hyder misunderstood or fabricated the conversation. 2 witnesses are exponentially more powerful than 1. Transaction 2 involves text message exchanges between Melania and Ivanka during July and August 2021. My office obtained these messages through a subpoena to Melania's phone provider. 27 messages discuss an IRS audit of Trump Organization tax returns for fiscal year 2019. On July 18, 2021, Ivanka texted Melania, "Accountants are asking about the Cyprus accounts. What should I tell them?" Melania responded, "Use the beneficial ownership structure we set up with your father. They can't trace it if you stay consistent." On August 3rd, another exchange. Ivanka, "IRS agent wants documentation on the $4.2 million transfer." Melania, "Refer them to the trust documents. Don't volunteer anything about the Cayman holdings." I wanted Melania under oath to explain what Cyprus accounts meant. What beneficial ownership structure was she referencing? What Cayman holdings was Ivanka being told to conceal from federal auditors? Those answers would have connected documentary evidence to criminal intent. Transaction 3 centers on offshore bank accounts where Melania held authorized user status. Between January 2019 and December 2022, $31.7 million flowed through 3 accounts, 2 in Cyprus, 1 in the Cayman Islands. Bank records show Melania as an authorized user on all 3 accounts, with Ivanka listed as the primary account holder. Melania's testimony could have explained the source of those funds. Were they proceeds from Trump Organization operations? Were they concealed to avoid taxes? Who controlled the accounts and what was their purpose? Documentary evidence shows the money, but Melania could have explained the why. Here's the legal significance. I already possess overwhelming documentary evidence, bank records, emails, tax returns, wire transfer receipts. I already have cooperating witness testimony from accountants and financial advisors. But when a family member, who was physically present, confirms what the documents show, that's corroboration. Corroboration eliminates reasonable doubt. It transforms "the documents might be misleading" into "the documents are exactly what the prosecution claims." That's why federal prosecutors value family cooperation so highly. I prosecuted Paul Manafort for financial crimes in 2018. His son-in-law's testimony about witnessing offshore account discussions proved devastating. Similar family dynamics, similar business fraud, similar evidentiary value. Melania's testimony would have served the identical function here. Ivanka's actual prison exposure. Now let me break down the real numbers Ivanka faces, because understanding sentencing calculations reveals why Melania's refusal is so consequential. Federal sentencing isn't arbitrary. It follows mathematical guidelines based on offense severity and criminal history. 4 counts of bank fraud. Federal statute allows up to 30 years per count, but judges use guidelines. For fraud involving amounts between $25 million and $65 million with sophisticated concealment methods, the guideline range is 97 to 121 months per count. Ivanka has 4 counts. Sentences run concurrently when conduct is related, so the practical range for bank fraud is 97 to 121 months. That's approximately 8 to 10 years. 3 counts of wire fraud. Wire fraud carries the same statutory maximum as bank fraud, but the guideline calculation differs slightly. For wire fraud at this amount, the range is 87 to 108 months per count. Concurrent sentencing yields a practical range of 87 to 108 months, roughly 7 to 9 years. 2 counts of tax evasion. Tax evasion involves a separate calculation based on tax loss. The IRS determined Ivanka's conduct resulted in $8.4 million in unpaid taxes. At that loss amount, guidelines recommend 41 to 51 months per count. Concurrent sentencing means 41 to 51 months, approximately 3 to 4 years. 1 count of conspiracy. Conspiracy guidelines stack with underlying offenses. Conspiracy to commit fraud adds 18 to 24 months. When judges sentence multiple counts involving related conduct, they typically run sentences concurrently but consider the totality of criminal behavior. The practical calculation is this: take the highest base offense, add enhancements for multiple counts, apply adjustments for acceptance of responsibility. Ivanka's total exposure without cooperation is 87 to 144 months. That's 7 to 12 years in federal prison. With Melania's cooperation and substantial assistance, I could have recommended a downward departure to 51 to 72 months, approximately 4 to 6 years. The federal system eliminated parole in 1987. Defendants serve 85% of imposed sentences. If Ivanka receives 120 months, she serves 102 months, 8.5 years. If cooperation had reduced that to 60 months, she serves 51 months, 4 years and 3 months. That's the difference Melania's testimony represented. 4 additional years of freedom, 4 fewer years away from her children, 4 years that could have been saved by telling the truth about what she witnessed. Instead, Melania chose silence. Judges follow prosecutorial sentencing recommendations approximately 87% of the time. When I recommend the high end of a guidelines range, I provide detailed justification. Lack of cooperation, no acceptance of responsibility, and obstruction of justice all justify high-end recommendations. Without Melania's testimony, my sentencing memorandum will argue for 118 to 132 months. With her cooperation, I could have argued for 56 to 68 months. That's a 62-month difference, more than 5 years. The broader criminal pattern. Ivanka Trump is the fourth member of this family I've charged with financial crimes arising from Trump organization conduct. When prosecutors charge multiple family members in connected schemes, it's not vindictive. It's following evidence of coordinated criminal activity. The defendant himself faces 34 felony counts of business fraud and obstruction related to falsifying records to conceal hush money payments. That case involves the same organizational structure, the same pattern of using business entities to commit fraud. Donald Trump Jr. was charged in August 2024 with 3 counts of tax evasion and 2 counts of concealing foreign income through shell companies. Same methodology, offshore accounts, hidden beneficial ownership, false statements to the IRS. His trial begins in September 2026. Eric Trump received immunity in exchange for cooperation against his father and siblings. His testimony described how the Trump organization operated as a family criminal enterprise, with each member handling different aspects of fraudulent operations. Eric's cooperation was the foundation that allowed me to build cases against the others. Now Ivanka faces 8 felony counts following the same pattern. Different banks, different tax years, different specific transactions, but identical methodology. All 4 cases involve falsified financial documents, offshore accounts to conceal ownership, use of Trump organization infrastructure, and coordinated family participation. In federal court, this is evidence of a continuing criminal enterprise. Outside court, it means a family-run business systematically used to commit financial crimes across multiple years. Not isolated mistakes, not misunderstandings, deliberate, coordinated fraud. I prosecuted the Gambino crime family in the 1990s. Different crimes, same structure. Father, sons, criminal enterprise disguised as legitimate business operations. The pattern is unmistakable. This investigation consumed 4 years of work. My team traced financial transactions through 23 countries. We interviewed 187 witnesses. We reviewed 6.2 million pages of documents. We executed 34 search warrants and issued 89 subpoenas. Melania Trump is the only person with first-hand knowledge spanning all 4 family members' criminal conduct. She witnessed meetings involving the defendant. She had access to information about Don Jr.'s offshore accounts. She participated in discussions about Eric's cooperation decision. She observed transactions central to Ivanka's charges. Her testimony could have tied the entire pattern together, demonstrating that this wasn't 4 separate prosecutions, but a single-family criminal enterprise. She chose not to testify. That decision protects the broader conspiracy while sacrificing Ivanka to the consequences. What happens next? The trial begins June 9th, 2026. That date is set, and no further delays will be granted. Jury selection starts that morning in the Southern District of New York Federal Courthouse. March 28th, final pretrial motions due. April 14th, evidentiary hearings on motions to suppress. May 5th, witness lists finalized. May 22nd, jury questionnaires mailed to 300 prospective jurors. June 2nd, final pretrial conference. June 9th, jury selection begins. I anticipate 3 days of voir dire given the case's publicity.